Your digital privacy is under siege, the Fourth Amendment in the age of surveillance. What if the government could know where you are, what you're thinking, and even predict what you might do next, without your knowledge? Now what if it could shut off your digital life entirely, not because you committed a crime, but because you held the wrong opinion? This isn't sci-fi, it's the edge of where digital surveillance and real power collide. And the only thing standing in the way? The Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures. It's the legal backbone of your right to privacy. The following cases updated the Fourth Amendment for a digital world, at least partially. In the landmark case Katz v. United States, 1967, the reasonable expectation of privacy was introduced. Then, in Kyllo v. United States, 2001, the court ruled that the police use of thermal imaging on a home is a search. In Riley v. California, 2014, the court found that a warrant is required to search a phone. But then there's the metadata loophole, which refers to what's often not protected. That is metadata, your IP address, call logs, location history. This data maps out your life, your routine, your habits, even your political leanings. Why isn't this covered by the Fourth Amendment? Well, that's where the third-party doctrine comes in. Now, let's review the third-party doctrine, the invisible leak in privacy law. The third-party doctrine says that if you voluntarily give data to a company, you lose your constitutional privacy in it. Key cases include United States v. Miller, 1976, where the court ruled that there is no Fourth Amendment protection for bank records, and Smith v. Maryland, 1979, which ruled that no warrant is needed for dialed phone numbers. These court decisions made sense, maybe, in a world before smartphones. But today, you voluntarily share data with third parties every time you use Google Maps, sync files to the cloud, chat on social media. That's not really a choice. It's the cost of functioning in modern life. The doctrine assumes that by using a service, you assume the risk your data could be handed over to the government. But did you assume the risk when your fitness tracker logs your sleep and heart rate? When your smart thermostat knows when you're home? When your rideshare app tracks your exact movements? The truth is, this doctrine is outdated, but it's still the rule. The first major crack in this doctrine came in Carpenter v. United States, 2018. The court ruled that cell site location data is too revealing. Police need a warrant to access it, even if it's stored by your phone company. Chief Justice Roberts noted in that case, a detailed chronicle of a person's physical presence encroaches on expectations of privacy. Carpenter didn't kill the third-party doctrine, but it created a path to challenge it. Surveillance is only half the threat. The greater danger is digital suppression. In authoritarian states, critics don't need to be jailed. They can be digitally erased, no access to banking, social media accounts suspended, phones disabled, travel restricted. In the US, we've seen geofence warrants used to identify all phones near a protest. Keyword warrants demand to know who searched for specific phrases. These broad demands resemble the general warrants the founders rebelled against. And yet, they're happening right now. Along with this, there's the crime control dilemma, and, let's be honest, crime control matters. Investigators need tools to stop terrorism, trafficking, and exploitation. However, there's a fine line. Tools meant to prevent crime must not be used to suppress dissent. We must also recognize that much of the data used to train AI for policing is biased, coming from various sources, including public online datasets, web scraping, and crowdsourcing. It can consist of text, images, audio, and video, which are used to teach AI models to recognize patterns and make predictions. Predictive policing in this digital age, therefore, carries many of the same criticisms as in the past but has a problematic air of infallibility. We must ensure that it is targeting criminal actions and not types of persons. Irrespective of the often heard phrase, "I don't care if they search," I have nothing to hide. In response to police surveillance, privacy still matters. Privacy isn't about hiding from authorities. It's about the freedom to live without surveillance. It's the right to research ideas, associate freely, and speak truth to power without fear of digital punishment or worse. Without privacy, democracy is just performance, dissent is just noise, and freedom becomes conditional. The Fourth Amendment was born in response to unchecked government searches. There needs to be a modern response ensuring those protections are preserved. The Fourth Amendment is not for sale act is one start, so is pushing courts to follow Carpenter's lead. Remember, without any response and the more we tolerate mass data collection and digital blacklists, the more we surrender our future.